well.
You're there as well? Okay, perfect. Hi.
Hi.
Great. Okay, well, I think we can now get started. So hello, everyone. Thank you for joining us today. I'll start by acknowledging that I'm joining you from unceded sovereign Gadigal land. This is, was, and always will be Aboriginal land. I pay my respects to elders past and present and extend that respect to all Aboriginal and Torres Strait Islander people joining us today. So welcome to Session 2, Shake the System, Using the Law to Bring Change and Accountability to Policing. My name is Ashley Bucket and I'm a Principal Solicitor here at the National Justice Project. Before we get started, I have just a few things to bring to your attention. Firstly, our session today is being recorded, so please switch off your camera and change your display name if you do not wish to be in the recording. And for best viewing, please set your view settings to speaker mode. Throughout this session, there will be references to sensitive topics, so please listen with care and note that free and confidential support is available through a number of services listed in the chat, which is also now open for you to share questions, opinions, and resources. And if you haven't already, we encourage you to add your voice to the call for alternative first responders by signing our pledge at alternativefirstresponders.com.au. We have two incredible panelists joining us for this important discussion today. Samara Fernandez-Brown is a proud Warlpiri woman and has been a relentless advocate for her family's fight for justice since the death of her cousin, Kumanjayi Walker, who was shot and killed by police in 2019. As a leader of the Justice for Walker campaign, she has tirelessly guided efforts through legal proceedings and continues her work with the Dajua Foundation to support Aboriginal and Torres Strait Islander families impacted by deaths in custody in her role as the Stop Black Deaths in Custody campaign manager. Samantha Lee is a supervising solicitor at Redfern Legal Centre, where she leads the police accountability and administrative law practice. She has played a key role in several key law reform campaigns and strategic litigation cases, including those related to COVID fines, strip search laws, and issues concerning children and fines. Prior to her current position, Sam worked for many years as a lawyer at Legal Aid New South Wales and served as a policy advisor within the Criminal Law Division at the New South Wales Attorney General's Office. So thank you both for joining us today to discuss where we are and what is needed to shake up the system to achieve greater police accountability.
Thanks, Ashley.
Let's head into some questions now. Here at the National Justice Project, we support our clients to fight for justice through a range of different mechanisms. We've seen that the legal system can provide some forms of relief for individuals and communities impacted by policing, but at the same time, there are often lengthy delays in achieving accountability and justice. How do these delays increase harm to communities and individuals? Samara, I might ask you to respond first. Thanks.
Of course. Thank you for the question, Ashley. In terms of the delays, I think just one of those obvious things where when something so important and so vital is constantly delayed, and for Aboriginal and Torres Strait Islander people in Australia, justice is often delayed, but in so many instances not received as well. And I think that just shows the message that we're not important and that responding to our needs isn't a key priority in this country. And so I think when you're delaying that response, it just keeps perpetuating that the view that we already have, and it really validates how Aboriginal and Torres Strait Islander people feel, where their systems are inherently violent and they're not working to be therapeutic for our people and for a future where we are feeling safe and we're being heard, and where our knowledge is being utilised to be safer for our communities.
Absolutely, thank you. Sam, would you like to add to that?
Well, just in terms of a litigation perspective, delays means that evidence gets a bit long in the tooth. And we also know that police go off on leave or they move to different stations. So things get a lot more difficult in terms of litigation. It's also, trying to manage clients' expectations, which can get obviously difficult the longer things go on. So it benefits particularly clients to make sure this gets resolved as quickly as possible.
Absolutely. And I might just stay with you for a moment, Sam, and ask you, given that current systems place police at the centre of first responses, what do you think is needed to change that as the default?
Look, it's a really big issue because it's not just about procedures and policy change. It's also about legislative change because most mental health acts across the country place police within as the main authority when it comes to detainment, transportation, restraint of people who have a mental illness or a mental episode. So, for example, even if ambulance calls police for assistance, that then places an obligation, a legal obligation on police to actually restrain that person and take them to a mental health facility. So not only do we need policy change, there's also a huge shift in terms of legal reform. The Acts allow police to use force, restraint, to detain, to enter without a warrant. So even if we get a new model, there's going to need a lot of change around the legislation.
Absolutely. Samara, what do you think in terms of what we need to do to change that default?
Yeah, I think that it obviously needs to happen because we're seeing instances where, when police are first responders, particularly in cases of mental health and where people need a therapeutic response, it often becomes violent and it has some really horrible outcomes for people. So I think it's absolutely something that is critical. I think obviously the campaign that your team is working on is really important in getting on and backing and giving support, but I think doing what we're doing in terms of consulting, because I think like even first responders, it needs to change, but it obviously needs to change for the different circumstances that are being responded to and for the different populations as well, like making sure that we are consulting and having a plan around responding to whatever that crisis might be and making sure that those people that are responding are not trigger points, because at the moment, obviously, police being a first responder is really triggering for First Nations people, but also people of colour.
Thank you. And I suppose turning to accountability for police misconduct, what accessibility measures are needed to ensure people who speak English as a secondary language have access to accountability, and what are the limitations to the current system and what changes are needed?
Was that for
Yeah, thanks, Samara.
No, that's okay. Yeah, obviously it should be an inherent right to understand what is going on. And where there is an instance where somebody speaks English as a second language, we absolutely need to accommodate for that. I think that there can be a lot of coercion that happens, particularly around the injustice system, like family members or people feeling like they have to take a plea deal or have to do this because they think that's what needs to be done. I think a lot of people are not given the time to properly understand the processes that are happening. So I think it needs to be a priority, absolutely, to have translators available, which, means that there should be translators, but also means that we should be succession planning and having programs where there are people, more than one translator. often you see there's only like one or two within the courts for a particular language. So like, well, for instance, it's such a big language group in Central Australia, but there isn't a a lot of translators. And so if one's not available and the other is somewhere else, it often means that people don't have access to basic things like understanding what their rights are. Yeah,
Thanks,
and
Samara.
I think you just
Sam?
mentioned that often people are speaking more than one language, 3, 4, 5. So, definitely needing to accommodate for that.
Yes, absolutely. Thank you. Sam, would you like to reflect on that in the context of your work at Redfern Legal Centre?
Yeah, look, there's different ports of call when it comes to access to services. Obviously, when something happens on the ground, there is a requirement for police to provide interpreters, but I have seen very little of that happen on the ground. But then there's the issue that once an incident has occurred, the difficulties of accessing free services, particularly if there's been a civil wrong or a complaint against police, then the number of free services available that tackle police accountability is very limited. And also for those who are on a visa, get very afraid of approaching or doing anything that may disrupt their visa, or fear that if they report a matter, particularly a policing matter, then that will impact on their visa. So I think it's quite a complicated issue that one needs, obviously, police procedures, but also access to services, and then information about how complaining or instigating a case against police, how that may or may not impact on visas for those who are coming into the country.
Thank you, Sam. Just a quick reminder to everyone that our chat is open for you to post some questions, and we'll come to those at the end of the session. So please do add in your thoughts and questions, and thank you to the people who have already done that. Sam, if we just continue the discussion a little bit more around your strategic litigation experience, what kind of legal strategies have proven most effective in challenging police misconduct?
Yeah, look, it depends on the issue, but obviously, looking at strategic litigation is something to consider, but I've always done it in line with a much broader campaign, to campaign first, which is what you're doing at the moment, advocating for a new model. In terms of litigation in this area, it's not easy. You can utilise tort law. If a person, for example, I had a client who was tasered by police were called to the scene on the basis of a welfare check, and there was consideration of whether that person then had a civil claim against police for excessive use of force, which is a tort around assault, battery, and false imprisonment and trespass. Now, there's lots of difficulties in this area because of, if I go back to the Mental Health Act and the authority that police are given under Mental Health Act. And police, when they go to a scene, the case law, there's an interesting case. It's a New South Wales case called Talovic, Talovic, 2014. And that does outline the considerations that the court looks at in terms of police powers in welfare or mental health checks. The court doesn't expect police to operate on a level of assessing someone as a psychiatrist or a psychologist. They're going there on the reasonable grounds that they reasonably believe that the person is mentally unwell, or they could commit a crime or hurt themselves or someone else. So it's kind of quite a broad test. It's a bit more of a layperson's test rather than looking at whether someone actually has a mental illness. And then the Act allows, as I said, use of restraint and use of force The court obviously does look at the aspect of denying someone their liberty in those circumstances, and the fact that someone actually hasn't committed a crime in most circumstances. It's just that they're unwell, and therefore that there's a balancing act between detaining that person for their own well-being and them not committing offence. So how far do those police powers go? I think the courts struggle a little bit with the power, which does mean it's quite tricky to litigate in this area. So in terms of strategic litigation, I don't think it's as clear-cut as some other issues, like, for example, strip searches.
Great, thank you, Sam. Well, we've spoken a little bit about the litigation response, but I'd be very interested to hear from Samara about, Samara, your thoughts on how we can use the law to ensure that change and accountability for policing addresses not only individual cases, but also historical and systemic mistrust of those same systems.
Yeah, it's very obviously a big topic and big discussion. And I think I'm coming from a lens in terms of like being hopeful. I also want to acknowledge that we're in a space where we're not seeing that change yet. So just prefacing that. But I think using an example, as my cousin's inquest as an example. So obviously there was the murder trial and that didn't go the way that we wanted. But in the coronial inquest, for instance, we had access to the text messages with the police officer that was involved with the death of my cousin. And so I think just using the law in terms of like having access to that evidence was really handy for us, because we'd been told time and time again that the anti-police force wasn't racist, there wasn't systematic and entrenched racism or anything like that. But we were able to use the law that it existed to be able to have access to that evidence, to be able to prove that from. So using that system against the NC police and the officer to showcase very distinct examples of racism, racist language, racist awards, racist just culture within the police force. So I think, yeah, that was really important for us because we often don't get that opportunity to be able to sort of use that, because we feel like the police are inherently protected or they have a bit more legal literacy or access to people that have the legal literacy to support them in these instances. And I think that really puts us as a disadvantage. So having access to lawyers that genuinely want to advocate, but also bring us along in educating us and giving us the resources that we need to be able to tell our truths in that space, was really, really vital for us. And in that instance, we were able to, have some really big instances of showcasing racism within the anti-police.
Thanks, Samara. Sam, what does it mean to you to use the law as a tool for change? Is it sufficient? And what are common barriers? Samara's just mentioned a few. And how can we improve the process?
Look, law for change, I think, should be seen as not the first port of call. The first port of call is actually developing community understanding of the issue and the things that need to change. You first have to develop a bit of a community public awareness around the issue before, I think, taking it to some form of strategic litigation. So having these discussions, sharing stories, Samara's story or her voice getting out there in the community is all very powerful. And governments are not going to act until they start to feel a bit of heat, or what we call in campaigning a tipping point, where they feel that if they don't act, it's more detrimental to them than if they do act. And that's very difficult to raise that heat. It can take years. And I often say when working in this area, sometimes it's not about you seeing the change. It's actually about handing on the baton to someone else. Excruciating as that is, Samara's probably felt this, that change is excruciatingly slow, that people have been advocating already in this area for years. I think one of the benefits now, particularly in New South Wales, is that we have the voice of police saying that they want change. And so that has added a powerful means for the government to then get on board. So, but until that time, when there's resistance from police, I think it's very hard to create those tipping points.
Thank you, Sam. And just to continue our discussion about the use of law as a tool for change, the barriers, and what Samara's just discussed about her own experiences in terms of using legal mechanisms to expose racism and to hold racism to account. Samara, just wondering if you could discuss some of the failings of the current legal system in addressing the racism in policing, and what are the opportunities to address this moving forward?
Gosh, the list of failures is huge, right?
Yes.
Across Australia, but also in our respective states and territories. Like speaking from the Northern Territory at the moment, awful. The situation that we're in at the moment is absolutely horrendous with the CLP. And you've got instances of bail laws being changed, so it's harder for people to get bail. The watch houses are stocked, you know, they're filled with people. It's so hard for people to get out. And those their circumstances in the watch house and in jail are unlivable. Just the state of those places are awful. And obviously a very, very punitive lens. It's not therapeutic. It doesn't work towards actually actually rehabilitating people or therapeutically supporting them to create changes. At the moment, there is, you know, in the Northern Territory, it's very tough on crime, but I will preface that by saying tough on crime when you're black, not when you're white, because as we saw, you can participate in a hit and run and not get criminal charges, which is horrendous if you're not Aboriginal or Torres Strait Islander or a person of colour. You've got that. You've got essentially the criminalisation of poverty, not being able to access transport if you're not dressed what they deem as appropriate. You've got the lowering of prices of alcohol, but then re-criminalising public drunkenness. Like, there is just so many failures. So, like, it's unfathomable. We've just, in the Northern Territory, we lowered the age of criminalisation, which is horrendous. We introduced spit hoods. Like, it's just, the state of the Northern Territory at the moment is awful. It's really awful. It is, it's gut-wrenching, and yeah. So just the failures on that is awful. And I think not only the failing of what the systems are saying and what they're showing, but I think also just the contradictions in it. So it would be different, I suppose, if that was the same law across populations, but we're seeing that it's not. So it is very evidently geared towards harming people that are First Nations or people of colour. Yeah, obviously, like with access to even lawyers and things like that, they're like, you know, you've got Niger and whatnot, but they're so under-resourced, so underfunded, and it's so hard because I think they're forward-facing in terms of working with people, working with clients, and so they might take the brunt. But I think we need to focus on the budgets in our states and in our territories, and where they're actually being spent and where they're being invested and not only where they're being invested. There's a lot of people that say that they're investing in justice reinvestment and whatnot. But again, money's being spent without actually consulting the communities that the money's being spent for. So I think just the failings as well in terms of properly consulting communities and empowering communities to make the change that they see fit. And that would then make the change long lasting and create succession planning. At the moment, there's just so many Band-Aid solutions that have no longevity. And so it's just money spent to tick a box, say that money's been invested in this way. But then at the end of the day, when the money's spent, the community's still left without a clear vision of where to go and what to do next. There's so much reliance on these systems that exist, which is really awful because the systems that exist at the moment are inherently failing our people.
Thanks so much for that insight, Samara. I just want to follow on from what you've been saying, and you've mentioned a lot about community-led responses. What role do you think truth-telling has to play in accountability, and what would embedding restorative justice and truth-telling processes look like in addressing police accountability?
I think truth-telling is, like that first step, or it's just like, in my opinion, just like the bare minimum to being able to open up that conversation, being able to be listened to. I think, speaking again from the perspective of as a Warlpiri woman, as an Indigenous woman, we have been told time and time again that racism doesn't exist and that the police are just doing their jobs and they have the right to participate in arrests how they deem necessary, those kinds of things. So that's the truth that exists for them. But then we keep missing out on the conversations that exist for the violence that our young people are experiencing. And I think because we're being told that the police are doing the right thing, it then means that it creates so much more hurt and so much more anger and so much more trauma because these young people are being hurt by this system, but then in the same breath being told that they need to follow and abide by this system. So they're essentially saying you should listen to your abusers. So I think being able to tell the truth about the harm that is caused allows us to have the conversation about alternative ways of responding, alternative ways to policing and alternative ways. And, like moving away from this just punitive sense, just to be punitive and just to punish and to outcast and to isolate, but moving into a way of being therapeutic about actually having community invested in young people and in their success and in their healing. I think that's really, really important. I think truth-telling as well, again, speaking from my experience as Kumanjayi's cousin, we'd known for a long time, right, that the anti-police has this culture of racism. But again, through the coronial inquest process, having the coroner say that there is systematic and entrenched racism in the anti-police, it was very validating because it's a lot of, we know this, but now people can't they can't say that it doesn't exist because it exists in this report now, which is really awful because our truth should be enough. Our experiences should be enough. But I think having that truth telling in the legal space or in the coronial inquest space is really important to help validate us and to, persuade the persuadables, to showcase the truth to people that might be sitting on the fence or might still be blinded to the authoritarian ways that we exist in Australia. So I think, truth is really important. And I think not only truth, but being able to tell truth in a narrative way, in a way, like Indigenous people are storytellers in our own right, historically and culturally. So I think being able to tell our truths is also very healing for us.
Thank you so much. You've mentioned a little bit about alternative responses. What do you think about in terms of situations of high need, such as mental health? How do you think we could use alternative responses to ensure a response that keeps everyone safe?
Yeah, I think there are so many different examples of things that we could be doing. Big conversation, but I think I know, again, as being a Warlpiri woman that has lived in Yuendamu, my family are from there, the police are in their trigger point. And like Sam was talking about as well, about the visa situation, it's kind of like you don't feel like even if you're the person in harm that you can call the police because you think that you're going to be looked at as the person that is in the wrong, or you're not going to feel safe in that situation, or you just have been mistreated by the police in the past, so that is an inherent trigger. And so I think in Yuendamu there was different responses. So they had we had the Warlpiri Kenya program, for instance, and so it was training local people from community in how to respond therapeutically. So rather than being the police that are called for a disturbance, the family members are called that work for Warlpiri Kenya. They calm, they see what's happening, they will de-escalate the situation, but also get a true understanding of what is happening. And then we'll talk with family to decide what the next steps are. If the police then need to come into the picture as the next step, then that'll happen, but with a clear picture already being brought to the forefront. I think having the police be the first people come in, especially in a crisis zone where, we don't know who's in the wrong, who's in the right, it just escalates everything. So I think it's different for different instances. So speaking specifically to Yuendamu, I think having local people respond is really important because, again, they speak the language. They have access to kinship. They know who's related to who. They know what could be a sore point in that argument or whatever is happening. And so I think that worked really, really well for Yuendamu. And I could see working well for other communities. But I think, again, it just comes down to what that community wants and what we're responding to. I think definitely when it has to do with mental health, we need to have people that are trained in responding to people in mental health crises, are trained to being therapeutic, are trained to not feel like somebody having a response to something is being violent or is putting you at risk. Like, I think there are people that might be responding to a situation, but you're inherently safe. They're responding to whatever's happening over there. And I think we need to know that people need to know and to not, not take that on, not internalize the situation that's going in. I think you need to go and being able to step back and have the lens of being able to support the people that are going through what they're going through without internalizing yourself in that situation.
That's incredible. Thank you so much, Samara. It's just so insightful. Really appreciate it. Sam, can I just turn to you for a moment? And just wondering if you could respond to the same question from a legal perspective. So how could we use law to ensure a response that keeps everyone safe? And does the current legal framework allow that, or does it require reform?
Look, first off, I certainly do think it requires reform, more of a matrix system where there's a really rigorous assessment of a matter that a triple O call comes through. There's no doubt about it, and I don't want to dismiss the fact that some welfare calls are very complex. There are difficult scenarios. It's unfortunate that police are tunneled into these triple O calls. I'm sure I have seen a lot of CCTV footage where police have tried to de-escalate, but they get very impatient. And then the time feels like it's weighing in on them and they just want to get the job done. So they'll take it to a point of de-escalation and then they just kind of tip over that because they just want to get it done. And that's at the crux of the escalation happens. Like, for example, if we take two different scenarios, we had a woman in Newcastle who was suicidal. She was in an apartment by herself. and she was no harm to anyone except for herself. In that situation should be dealt differently, for example, to we take the horrific scenario of the Bondi Junction stabbings where the person was quite mentally unwell, had a long history of psychosis. Those two scenarios are completely different. One's out in public, the person is obviously incredibly dangerous and in a very horrific psychosis where they're going to hurt other people. And then the other scenario is when they're in their own apartment, they're not in public, and they're only a threat to themselves. So in those situations, I definitely think police should not be the first port of call where the person is purely a danger to themselves. And I think what you need in most of these scenarios is time, patience, and de-escalation skills, which is something that police are not taught. And it's these three factors which will make a huge difference. If we take, though, a person with a weapon out in public, I mean, I don't think you can rule out the fact that maybe police need to be involved in those situations. And I think there needs to be consideration of the safety of the community, the safety of the first responders. We can't just have this blanket, look, let's just not have police. I'm not saying that police should be the first port of call, but I think there are scenarios where there is a need for force to prevent danger to other people. So I don't think there's one answer that fits all scenarios. I really do think it's a matrix of assessment, a really rigorous model that will filter out a lot of people that will are just suicidal and need really immediate crisis care. And then you have the scenarios where there's maybe a danger to the public.
Thank you so much for that, Sam. Just to let everyone know, I think we've got 15 to 20 minutes left in our session, so please keep your questions coming. I'm actually going to turn now to some questions from the audience. And so, Sam, just to follow on from what you were saying, we've had a question: in certain mental health circumstances where there may be a potential for violence, would it be preferable to have a legislative change where the medical or mental health professionals responding had lead of authority over police actions? What do you think?
I think you have to be very careful around constructing legislation. I think the model should then feed the legislation. We haven't really come up with the ideal model as yet. All I know is from my experience from casework is that there's two scenarios that take place. There's one where a person, a welfare call is made and police go to the place. The person does not have a weapon. However, they are undergoing, an episode. They've got paranoia. That paranoia is saying to them that people are after them, that they're going to get hurt. And as soon as they see police, they pick up a weapon. And it's the police that actually drives them to grab the weapon. I have seen that through my own practice, through the body-worn video footage. So in that case scenario, you don't want police involved as the first port of call, because they are the ones feeding into the psychosis that the person has. I think in the majority of scenarios, you want to try and have a model where harm reduction is the first port of call, and it's a mental health-led model. But as I said before, there will be exceptional circumstances where that will not be appropriate just because of the matrix of factors that could contribute to the harm of other people.
Thank you, Sam. Samara, turning to you again, what are your reflections on what you think might compel decision makers to act and actually hold police to account if evidence of rife racism has not done it? So we've discussed a little bit just now with Sam about legislative change. What do you think might be needed to actually hold that racism to account?
I think that we need a collective voice. because I think like Aboriginal, Torres Strait Islander people of colour have been saying this for a long time, but we are the minority. So I think that we need a collective voice. I think that there needs to be not a them and us issue. Like it can't be, oh, I don't experience racism, so I'm not going to speak on it. Allies are really important for this conversation and are almost more important. Like, you know, a spotlight and put First Nations, people of colour, on pedestals and to speak about those topics for sure, but where you can use your privilege or your networks and speaking in spaces where we might not have access to, you need to be there. It's an everybody problem. Racism affects everybody. Whether you see it, whether you don't, whether you're oblivious to it, it absolutely does. And even to climate conversations, racism affects that because there are a lot of First Nations solutions that existed, and if we were platformed to be able to bring about that healing, we wouldn't have the issues to the same degree that we do. And it's racism that says that First Nations voices aren't as qualified to speak on these things or aren't as educated. So it's an array of things that we could be benefiting from, but it's up to everybody else also to have those conversations and to escalate those conversations and to be outraged by it. You know, like I think that is really, really important because like we see with campaigns, it comes down to the pressure on the government. Government might not even care about the topic, but if they know that the majority of their citizens do, then they know that they have to do something about it. And so I think it's, yeah, we all just need to be on the same page about how awful racism is and how dangerous it is and how it actually affects everybody.
Look, you're absolutely correct, and thank you for such a generous and inspiring response. To follow on from that, we've had a question from an emerging law student who asks, do you have any guidance or direction for someone coming into the legal profession with a strong political and community purpose? And I think that's a great question because, as you say, we do all have a collective responsibility, but would you like to respond to that?
Yeah, I think in law and like there are lots of different careers that this can be relevant to, but I think in law, I think just to keep your humanity and don't be desensitized to things. I think when you're seeing things so often, say racism, for instance, it might be like, oh, this happens so much and become desensitized to it. I think don't. I think that whatever fire that sits in your belly that wants to help people, I think you need to feel that. Don't let that dim. And I think just be like, have the desire to educate in terms of like understand, consume the knowledge that exists, make sure that you are educated in everything that you're being taught. But it's, like reconstruct it in a way that the gaps exist. So, again, First Nations people, we talk about decolonizing spaces. And so you can deconstruct something in a way that supports people. If you're in a space where you're speaking to somebody that doesn't have access to a translator, but you know that conversation would benefit from, like, go out on a limb and make sure that you can get access to that resource or just fight hard. But I think, just really keep that fire burning, keep your humanity intact, but also I think reach out to people that inspire you or stay up to date with cases that inspire you, because I think when there's so much happening in the world and when it feels so grim, sometimes it's so easy to get bogged down by it and like feel like the fight's not worth it, or what small thing you'll do might not make a difference. But we all can do so much, and those small things turn into big things. And so I think just like always do your best. And even if it doesn't feel like you're making a dent, I can assure you that you will, because there's a lot of people that don't care, and we need more people that do. And by being one of those people that care, I'm sure you'll impact whoever is who you'll work with.
That's incredible. Thank you. Sam, would you like to respond to that same question? Any words of wisdom for an emerging law student hoping to work in this space and make an impact?
Yes, I love hearing from people that are emerging into the practice. It's not linear careers. Give something a try. Sometimes it's a process of elimination, and if you've got a passion, then you just got to pick organisations that you think will align with your principles. Community legal centres, some private firms who are quite social justice focused. So you've just got to pick an area and go and try something. Yeah.
Ashley, can I just add something extra on?
Thank you. Of course, no. Please go for it.
I think as well, don't be offended by the reaction that you get with people. I think, understanding that if there is somebody that has been in the system for a long time, they've probably been failed, or they probably had experiences that weren't great, or, sometimes turnover rates can happen, so they feel like they might have fell through the gaps. So I think just don't.
Okay, I think that Samara might actually be frozen for all of us and not just me. Hopefully she returns in just a moment because she's been so incredibly insightful and generous with her comments. So I'm not sure if you can hear us, Samara, but you've dropped out. Hopefully you can jump back on in a moment. And I'll follow on from that question by throwing to you, Sam. Amazing insight and words of wisdom from both you and Samara for our emerging law student. Turning to how we translate that into practice as practitioners and advocates, let's discuss a little bit about policy in action and reform in action. Oh, Samara, you're back.
Yes,
you did cut out a little bit. Would you like to just finish your last couple of sentences before you dropped?
What was I on?
Words of wisdom, your follow-on words of wisdom for an emerging law student, and you were talking about, don't be jaded in the work you do and acknowledge that people may have had many interactions with the system, and this is something that I see myself as a practitioner. You need to remember that you, as a lawyer, are often a representative in a way of a system that has caused harm for many generations, and you need to, not take that personally and just do the best you can to support your clients to navigate it.
Yeah, 100%. Like, jaded is the perfect word. Don't be jaded by people's reactions to you. If you have that intention, and it will 100% shine through at some point. So I think just keep showing up with that intention and keep showing people that you do care and that you want to show up. And I think like transparency goes a long way. Like you can also say like, I really want to do this. There are limitations to what I can do, willing to do. And I think sometimes just speaking out loud is really important. I think transparency goes a long way, and vocalizing how much you do care about things and you do want to, support where you can. I think, that's really important. Just keep showing up and keep, just meeting people where they're at and being kind.
Thank you so much. That's so lovely to hear, and excellent words of wisdom from both of you. Just to, I suppose, move into how we translate that into practice and advocate for reform, I'm interested in hearing from both of you, and Sam, I might throw to you first. Could you speak to the practical considerations you've seen in your work that are important when coordinating a legal policy and or campaigning approach to first responders?
Well, I think the practical consideration is the narrative, like what is it that you're trying to achieve. Obviously, you can look at models from other jurisdictions, that this, I think this is not an easy issue. So trying to break it down into concepts that people can grab and understand is important. In terms of change, I mean, you're looking at change on various levels, obviously around standard operating procedures for police, but also issues around the narrative, particularly around basic human rights of people who do suffer from a mental health illness should have access to the same services as everyone else. And I think that's a really strong narrative that should be out there in the community, that a person who is already in a disadvantaged situation because mental health does affect them financially in terms of their homes, access to healthcare, that they should be able to ring 000 without fear of injury or death. That should be the number one concern, and it's in a democratic society like Australia. As I said, the services should be available to all, no matter on their mental health standing.
Thank you, Sam. Really appreciate it. So you may have just seen a 2-minute warning pop up. Unfortunately, that is our sign to wrap up for today. I want to thank our incredible panelists for your insight. Really appreciate your generosity in your responses and for taking the time to speak with us today. Thank you to our brilliant audience for joining us and for your questions. I'm sorry that we didn't get to all of them, but next time. So let's wrap up now and continue the conversation to rethink how law can bring accountability and change to policing in the future. Thank you so much again, everyone.